investigation prior to his investigative interview. You did everything under the statute. So long as the law enforcement agency fires that officer before a court can order, then there's no remedy under the statute. That seems
well, it does say that with deputy sheriff, doesn't it? Right there in the statute, doesn't 112.535 say that this chapter shall not be construed to restrict or otherwise limit the discretion of the sheriff to take any disciplinary action against deputy sheriff, including demotion, reprimand, suspension, or dismissal. So doesn't it flat say that with regard, you mentioned deputies before, with regard to the deputy, that whether they do this or not, this doesn't restrict the sheriff's right to terminate.
This is the District Court of Appeal, City of Miami versus Cosgrove, Your Honor, and it was in 1987, December 22nd, 1987. In that case, the court held it.
Third district, you said?
That was actually picked. I wasn't holding, but it said you can do it.
Yeah, it's actually on page 4. Your Honor, it says if an officer is dismissed without notice, the agency can be compelled to provide proper notice, and if that officer is refused review by the complaint review board, under appropriate circumstances, the agency can be compelled to grant such relief. So the courts have upheld the validity of the statute beyond dates for which the officer is fired. If you fire them in violation of the statute, that doesn't end your statutory rights. It doesn't terminate them on the date of dismissal. You still have rights beyond the date of dismissal. Otherwise, there's no way, those protections are lost.
Well, I haven't read this case, but I'm looking at the paragraph above what you're quoting from, and it says they're saying we think a sister court in the 4th District gave a correct construction of section 112.534, which is the actual statute we're convened here today about. And it says we think the 4th District gave a correct construction where the 4th District decided that the law enforcement officers were required to bring their claims for reinstatement to the appropriate administrative board and were not entitled to avail themselves of the injunctive remedy of section 112.534.
Then it goes on, Your Honor, though, to say this section operates only to immediately restrain violations of policemen's and compelling performance of the duties imposed by section.
Right, and isn't the implied word in there that we would read in by implication the ongoing
after a notice of dismissal
violations?
Well, it says, thus, when an officer under investigation is being interrogated without the benefit of counsel, the agency may be restrained from violating his rights without counsel. If an officer is dismissed without notice, the agency can be compelled to provide proper notice.
Right,
and it goes on, it says, and if this officer is refused review by the complaint review board under appropriate circumstances, the agency can be compelled to grant review.
Right, but all that's separated by semicolons. That's not a run-on sentence. So I read all that in the disjunctive. So if you're still employed and you're refused review, the agency can be compelled to grant such a review. You're still being investigated. On another situation, if you are dismissed without notice, then the agency can be compelled to provide you with proper notice. So there are all kinds of rights, but I don't read that to say, I think as you're reading it, that this means, which is dicta anyway, I believe, but that it means that where you have already been dismissed, you get an injunction to require a compliance review panel to be set up to determine whether your investigation is being conducted properly, since there is no more investigation since you've been dismissed.
If that was the case, Your Honor, if you're dismissed, how can you compel them to provide you notice, as the statute says, if in fact the statute has no less applications? The application of the statute, and this is to give you those rights, and Your Honor, I think that's the argument is we couldn't do any more than what we've done. The officer.
That may be true. Look, I'm not attacking you or your client for sitting on your hands or anything. I'm simply trying to figure out what this particular statute was designed to do with regard to protecting the officer, and it appears to me it was designed to prevent ongoing unfair investigations. And that therefore, I'm concerned that if there is no ongoing investigation at all of any kind, then it is futile and not necessary to enter an injunction to set up a review panel to stop an unfair investigation where none's being conducted. The person's already been terminated. You said so yourself just a little while ago when you were arguing. All right, let me stop for a moment. And just in the interest of procedural due process, we'll let Mr. Chumley get a word or two in edgewise.
Your Honor, actually, the points you've been making up until this point, it's pretty much been the position of the county.
Well, just because I made them doesn't mean they're correct.
Well, I mean, what I'm saying is I don't want to repeat what you've been getting at. That is what our position is. That's in our petition. The issue, we agree that it affords prospective relief in situations where an ongoing investigation